you have said that President Trump must abide by the court-issued judgments. He may refuse to abide by the reasoning and opinions accompanying those judgments when the reasoning is contrary to law. I totally don't understand that.
Senator, I see I'm short on time. I would refer you to the article because we give a concrete...
No, what does that mean, the reasoning? I mean, doesn't the president have to follow the decisions of the court?
The judgments of the court. So Dred Scott was the example I gave where Abraham Lincoln said he'd be bound by the judgment. So with respect to the particular individual in that case, he would apply the reasoning of the court, but he would not extend it any further because the court egregiously misinterpreted the Constitution.
So the president is the one who decides which parts of a judgment in which parts of an order he'll apply or not?
Absolutely not. The president is bound by orders of the court.
And Dred Scott, the Supreme Court basically said Dred Scott had no rights because he was African American, right?
That's correct.
In that law, that decision, which is a total disgrace to our history, you're saying that the president could disregard that decision?
A heated Senate exchange exploded after a Trump nominee defended originalism, and Senator Welch fired back with a question that stopped the hearing cold. How could the founders possibly have imagined the internet, AI, and modern America?
Could you define textualism, Mr. Flowers?
Yes, absolutely. Textualism is, in my view, textualism and originalism are the same thing. Textualism is with respect to statutes, originalism, the Constitution. And the view is that words have a fixed meaning when enacted into law, and courts should apply the law according to that fixed meaning.
So, I mean, does that mean that the judges have to go back to what the meaning of the word was when the Constitution was written in order to interpret it in today's situation?
So it would depend on the constitutional provision in question. The 27th Amendment, for example, was ratified in the 90s, and so it'd be you wouldn't have to go back.
Talk about the Constitution. What you told me, originalism, textualism are the same thing. And essentially, it says we've got to go back to the original document, right?
That's correct, Senator. The original public meaning at the time the document was ratified.
Right. And, of course, at the time the document was ratified, it was passed, we didn't have the AI, we didn't have the internet, we didn't have the government we have. Isn't that correct?
That is correct, Senator.
So there's no way that the people who wrote the document, using the words that were available to them, had in mind the application of those words to what now exists in the 21st century. Would you agree with me or not?
But they did agree with broad principles that can be applied to those technologies.
How? How did the writers of the Constitution have a thought about the internet? Explain that to me.
Let me give you an example with a case. There's a case called Kelo that my former boss, Justice Scalia, wrote about thermal imaging of homes. And if a thermal imaging device, which didn't exist at the founding, could peer into a home the same way that you could only peer into a home at the founding by entering, then that would constitute a search. The other point about originalism...
Isn't that an interpretation?
Yes, originalism does require interpretation.
Right. So there is a application of a theory that textualism, originalism, is founded on the words in the meaning that they had at that time, and then the interpreter, a judge, is then applying his or her judgment as to what that author would do with respect to something that didn't even exist a couple of centuries ago, right?
True. As with respect to law, oftentimes lawyers must draw analogies.
You know, quite seriously, isn't that pretty weird?
I frankly don't think it is. The majority of today's Supreme Court is textualist, and the more important point is that textualism leaves that sort of updating largely to the political branches. You trust Congress and the state...
You know, on the leaving things up to the Congress, you argued against the price negotiation that was part of the Inflation Reduction Act to provide better prices for folks who are buying prescription drug medication, right?
That's not quite right. We argued that it's a taking. So we did not seek to strike down the law, but rather...
So even though the government provides patent protection so that there's price pricing power for the intellectual property, even though the government provides Medicare and Medicaid through that prescription drug access, and even though the government provides employer-sponsored health care with tax benefits that provide health insurance through employers and creates a market for the drug companies, it's impermissible, and according to your brief, for the government to try to negotiate a situation where instead of paying retail when they're buying wholesale, we can't negotiate on behalf of consumers? That was the text. That was the thrust of your approach?
Senator, the brief was filed on behalf of a client, but the position was not that that would be impermissible.
Sorry, your personal position on that.
Well, I can't state my personal position because it's a matter of pending litigation and under the canons of...
Well, it's over. I mean, the Supreme Court said it's okay.
I believe the case you're talking about is still pending at the Supreme Court.
All right. You know, I want to go back to what my colleague, Senator Kennedy, was asking. You said that the federal district courts, not the, actually, you have said that President Trump must abide by the court-issued judgments. He may refuse to abide by the reasoning and opinions accompanying those judgments when the reasoning is contrary to law. I totally don't understand that.
Senator, I see I'm short on time. I would refer you to the article because we give a concrete...
No, what does that mean, the reasoning? I mean, doesn't the president have to follow the decisions of the court?
The judgments of the court. So Dred Scott was the example I gave where Abraham Lincoln said he'd be bound by the judgment. So with respect to the particular individual in that case, he would apply the reasoning of the court, but he would not extend it any further because the court egregiously misinterpreted the Constitution.
So the president is the one who decides which parts of a judgment and which parts of an order he'll apply or not?
Absolutely not. The president is bound by orders of the court.
And Dred Scott, the Supreme Court basically said Dred Scott had no rights because he was African American, right?
That's correct.
In that law, that decision, which is a total disgrace to our history, you're saying that the president could disregard that decision with respect to anyone else other than Dred Scott?
That was Abraham Lincoln's position.
No, I'm asking your position.
Well, as a nominee, I don't want to talk about my personal views or how I would foreshadow a particular case, but the position I was advancing in the speech to which you're referring is that the other branches are absolutely bound by the orders, but they do not necessarily have to abide by the reasoning of a particular opinion in future cases with different parties.
My time is up. I'll yield back. Thank you.
Senator Booker.
Thank you very much. Mr. Schwartz, the independence of the judicial...
The hearing erupted into a sharp constitutional showdown when Senator Peter Welch challenged a Trump judicial nominee over the philosophy of textualism and originalism. What started as a legal discussion quickly transformed into a broader debate about whether America's Constitution should be interpreted strictly by its original meaning or adapted to fit a rapidly changing modern society. Welch repeatedly questioned how judges could apply centuries-old language to technologies and realities the founders never imagined. The nominee defended textualism by arguing that constitutional principles remain fixed even when society changes. According to his argument, judges should interpret the law based on the meaning understood when it was written, while allowing Congress, not the courts, to update laws for modern times. But Welch clearly wasn't buying the simplicity of that explanation. He pushed aggressively on the idea that judges inevitably inject personal interpretation when applying old language to entirely new circumstances like artificial intelligence, the internet, and digital privacy. The tension escalated even further when the conversation turned to presidential power and court rulings. Welch appeared stunned by arguments suggesting a president may not always have to follow the reasoning behind Supreme Court decisions, even while obeying direct orders. The nominee referenced Abraham Lincoln and the infamous Dred Scott decision, arguing that presidents and other branches can reject flawed constitutional reasoning in future cases. That exchange immediately raised concerns about executive authority and the limits of judicial power. What made this hearing especially compelling was how it exposed the growing ideological divide inside American law and politics. Supporters of originalism argue that sticking to the Constitution's original meaning prevents judges from becoming lawmakers themselves. Critics argue the philosophy risks freezing the country in the past and ignoring the realities of modern life. Welch's repeated disbelief, especially when he asked, "Isn't that pretty weird?" captured exactly why this debate has become so politically explosive. By the end of the hearing, the exchange became about far more than legal theory. It became a battle over who ultimately shapes America's future, elected lawmakers, judges, or the Constitution's original authors from centuries ago. In today's political climate, where Supreme Court decisions influence everything from elections to healthcare and executive power, this debate is no longer academic. It's central to the future direction of the country itself.